finally didn't. Boris, to make our task even more difficult, told us we should not only refer to the Commission's, to the practice of the Commission and to the EU law in that respect. We should also have a look at the national laws, how it is when it comes to the question of confidentiality of national competition authorities, cartel files, and also files of national courts. And here, coming back to the subject matter, to the topic of our panel, it's really a divided world, I think. I think the national rules on access to files, especially in purely national cases, but also in cases involving Article 101 before national competition authorities, they are very different in the various member states, which again I think increases the risk for a leniency applicant. If you have a multi-jurisdictional leniency application, you can never be sure that there could be one country where it is easier for a potential private claimant to get access to your leniency application, at least in one country, and then the applicant or the private claimant could maybe use this leniency application also in other jurisdictions if it helps him as evidence in his private claim. And to give you one example, in Austria, we have a clear option by our legislator to protect leniency statements and to protect the file. We have a clear obligation or a clear provision in our Cartel Act which says access to the file is only granted if all parties to a cartel proceedings agree, also the defendant. So that should be actually clear that a private party would not get access. Nevertheless, there's a loophole which we saw in our biggest private litigation case in Austria concerning a cartel in the elevator business, which was heavily fined for Austrian standards by the cartel court and which now is litigated. The claimants got access via criminal proceedings because there was also a criminal case pending. It was a prosecution of certain members of the cartel, natural persons. The private claimant got access to the criminal case because it's possible in Austria that you lodge your private claims in criminal proceedings. And then the Supreme Court decided the file has to be granted by the cartel court to the criminal prosecutor because the prosecution of criminal acts is even a higher interest than the safeguard of leniency applicants. So via this criminal proceedings, access to all, the entire cartel file could be managed to get in this Austrian case, which shows there can be always loopholes which could be used by creative lawyers especially. We have mentioned several times the Fleiderer judgment. Since this judgment was finally issued by the European Court of Justice, I think 2 days ago, the court was faster than I could be in my slides. But this question, this case should have actually fully clarified the question at hand, because the question in this case was whether a national competition authority would in fact be obliged or entitled, may give access to a private claimant, to a third-party private claimant, to its files for the purpose of bringing a civil law litigation claim. The Advocate General said no, because that would harm the effectiveness of the leniency system. The Court of Justice, as we have heard several times, did not follow the Advocate General. He played the ball fully back to the national authorities. He didn't give any guidance. He just said it's up to the national authorities to decide on a case-by-case basis, taking into account the individual circumstances of the matter. As far as I read the judgment today, I read it before, there's no guidance at all. It's just fully unclear still. We are actually back to the basics or to the beginning of the whole discussion. I think in the future it will be even more risky to have a leniency application in terms of private enforcement, because you can never be sure. It's really up to the national courts and national competition authorities to decide whether a third-party claimant is provided access to the file. That means also, and I'm coming almost to the end of my short presentation, that if, and I think it was already touched, I wasn't there, but in the morning in the first session, I think the question and the risk assessment that an undertaking has to undertake before it decides whether it files, especially multi-jurisdictional leniency or not, has become even more difficult. In Austria, also I think in Germany, there's even a corporate law responsibility of the management of a company to make the right decision here and to really weigh the risks and benefits of a leniency application. You have on the one hand, of course, the risk if you don't file a leniency that another one does it and you're not the whistleblower, the other one is, and you get a high public law fine. If you decide to be the whistleblower, you have to now really consider what's the risk, in fact, that private damage claims could be brought. What's the risk that if they are brought, that there is enough evidence for the private claimant to prove the damage itself and the causal link between the infringement and the damage. And that is related again to the question, what is the possibility and how high is the likelihood that the private claimant will get access to the leniency applications in the national files. And as I said, this is very open. It was already mentioned earlier in the previous panel, I think a best practice guideline, really more or less state of the art already for leniency application is that the companies have or lodge an oral corporate statement to the leniency applications orally and not in writing, because that is of course a higher protection. And I think in the future it will also be very important to carefully draft the wording of the leniency applications, because, as already said earlier by you actually, for an infringement of Article 101, it's not necessary to admit, or as a leniency applicant, to admit any negative price raising or whatever effects on the market. It is sufficient to say there was an infringement, there was an agreement or a concerted practice on the market, but that should be it, and you should, undertakings and we as lawyers, I think, should be very careful, even more careful now in the future after the plenary judgment, how we draft the leniency applications as at a low level as possible, but of course you have to provide some evidence to the Commission that it accepts the leniency application as such. If you are too abstract, then of course the Commission will say we don't accept it, and then it's even worse, because then the Commission knows that there's an infringement and you don't have leniency protection. I think I would leave it like that. I had 2 slides also on the related subject of legal professional privilege, but I think most of you will know the ACTSO decision, which actually only clarified that in-house counsel communication between undertakings and in-house counsel is not protected, and maybe for your country it will not be, for the country I think Croatia, for the host country, it will not be an issue in the future anymore, but so far the rule is still that non-EU external counsel is also not privileged by the legal professional privilege, which would be LPP and not LLP, I should say. And again, when we look at national rules in that respect, it is a very divided world, I think. If you look at the question how communication with lawyers is protected in the national procedural laws, for example, in Austria, our competition authority refuses to accept the legal professional privilege in purely Austrian cases at all, whereas in the UK, as far as I know, even in-house communication is protected. Well, thank you. It was just a short presentation. I hope I gave you some ideas, and I'll pass on to you.
James, please go ahead.